Judgment in the matter of Cartier International AG and others versus British Telecommunications Plc and another.
Lord Sumption will explain the decision of the court.
This appeal is about website blocking injunctions. The internet has become a powerful tool for pirates seeking to sell counterfeit goods under bogus trademarks or to distribute material, usually films, in breach of copyright. The internet provides them with access to a worldwide market, and it enables them to conclude sales with practically complete anonymity. The scale of the problem is apparent from the experience of the three respondents to this appeal, who manufacture and sell luxury goods under the well-known trademarks and have identified some 46,000 websites which offer infringing copies of their products. In recent years, the High Court has devised a form of injunction requiring internet intermediaries, such as internet service providers or ISPs, to block access to the offending websites and any other IP address or URL to which they may migrate. Initially, such injunctions were made only in copyright cases. This is the first case in which a website blocking order has been obtained to protect a trademark. The High Court and the Court of Appeal decided that the jurisdiction to order the blocking of a website extended to cases of trademark infringement. Before the Supreme Court, the issue is much narrower. The ISPs against whom the orders were sought no longer dispute the jurisdiction of the court to make such orders against them. Their case is that the trademark owners should have to indemnify them against the costs of complying with such orders. Hitherto, the practice of the High Court has been to leave the costs of compliance to be borne by the intermediaries, and the Court of Appeal has declined to interfere with this practice. The question for the Supreme Court is whether the current practice of refusing to indemnify ISPs against these costs is justifiable. The Supreme Court holds that it is not justifiable, and that in principle, trademark owners who want to get orders requiring ISPs to block infringing websites should pay the costs of compliance. The reasons are set out in a judgment which I have prepared and with which the rest of the court agrees. Those reasons can be quite shortly stated. First, ISPs are not themselves guilty of any infringement of trademarks. They provide an interconnection service which enables people to access websites, but they have no editorial control over the material on those sites, and under EU law, they are not even allowed to monitor it in order to acquaint themselves with their contents. They are therefore in the position of innocent intermediaries whose facilities have been used by pirates to pursue an illegal trade, but without any active involvement on their part. Outside the domain of intellectual property, the High Court frequently issues injunctions binding on innocent third parties which require them to assist the victims of wrongful conduct by third parties in one way or another, for example, by blocking bank accounts or by requiring them to give information. In these cases, the practice is that the intermediary can be required to assist, but should not have to do so at its own expense. It is entitled to an indemnity. There is no principled reason to depart from that practice in the case of website blocking orders. Secondly, although national laws concerning intellectual property rights have been partially harmonized by various EU directives, questions of procedure, including the incidence of costs, are matters for national law. They are not covered by the relevant directives. The only limit on the incidence of costs under national law, which is imposed by EU law, is that the costs must not be so excessive as to undermine the EU law regime for protecting intellectual property. No one suggests that the relatively modest costs of complying with a website blocking order offends against that principle. Thirdly and finally, this court does not accept the argument urged on behalf of the trademark owners, and which seems to have commended itself to the courts below, that ISPs are indirectly benefiting from the pirate trade because it boosts the volume of traffic on the internet. Website blocking orders are sought by trademark owners for the sole purpose of defending their own commercial interests. The protection of intellectual property rights is an important public interest, but it is properly a cost of the businesses which own and exploit those rights. An ISP has no legal responsibility for trademark infringements by websites which people may access through its services, and the protection of other people's trademarks is no business of theirs under the current law. For these reasons, the appeal will be allowed, and the orders of the High Court will be varied so as to require the trademark owners to indemnify the ISPs in respect of the reasonable costs of compliance, save for two heads of costs which it is agreed should be borne by the ISPs in any event.